and now they are walking back to Parliament. You could see the team there. I don't see Mr. Muite, Senior Counsel Muite,
but I do see the rest. You can see Ndegwa Njiru, you can see Tom Macharia, you can see Ongaya, and yes, you can see all of them. So I can't see Paul Muite there, who is the lead counsel. But they are heading back, and this is just 5 minutes to the time when the Deputy President is meant to be making his presenting his evidence before the Senate. So we wait to see whether they will be bringing a message or whether the Deputy President is about to arrive. We don't want to assume until it actually is the case. But what we clearly don't see as of now is we don't see the Deputy President, we don't see his lead counsel, and so we wait to see what message is going to be communicated to the House and to the country at large, because everyone is following this in the next few minutes, which should be in the next 5 or 4 minutes, according to what the Speaker had put out to as the timeline within which he was meant to have been brought back to the Senate, and aside from that, he should be presenting his evidence to the Senate. Sorry, Rosalina, I interrupted you.
Yeah, I was just trying to paint a picture of a scenario that maybe we might find ourselves with once the House resumes the sitting. Remember, the legal counsel of the Deputy President said that he has been taken ill. And I think that is a factor that even the courts will actually take into consideration. When people move to court to seek conservatory orders, one of the things they always look, is it a life and death threatening issue? So the fact that the courts have been very reluctant to injunct Parliament, maybe in the case now that the Deputy President is not available to come and appear in court, they can actually use that to secure the orders, so that they suspend the sitting of the Senate to give him time to recover. And that could just also play as a scenario in whatever we are.
But would it change the fact of the matter? Like,
yeah, I mean, we have something in law we often call you go to court to enlarge time.
Yeah.
Okay.
Yes,
When
yes.
time-bound things don't always have to be time-bound. So
Yes.
if you're late with filing a document in time or something,
Yes.
or even sometimes even the statute of limitations can be extended.
Yes.
So I think this is Rosalina actually brought up a very interesting dimension of it, that somebody can actually go to court and say, look, this thing ought to have been concluded because the Deputy President fell ill, enlarge time, and I think the court would probably give
orders.
another 7 days. Because if somebody is unwell, he's unwell.
He's unwell,
We go
yes.
to court every day. If a witness falls ill on the night before, you let him do that.
yeah.
And
I think I'm just curious, if say this was to happen and someone goes to court and they get another 7 days, what would it change in terms of the facts are not changing, or my presumption is that
It will prolong his time in
prolongs
office
it,
because
but
he
it gives
remains.
the DP time to recover and be in a position to defend himself.
Yes.
It gives him the right to be heard.
Okay.
He says, look, he's unable to, he's due to be heard. He's his only witness
Yes.
for his case.
Yeah.
He needs to be heard. He wanted to, but has fallen ill.
okay.
So
So I
extend the
think I was
time.
asking from the perception of those who presume it's a strategy, you know.
I don't think it's let's give him
Yeah,
let's benefit of doubt.
Yes, and we
Remember
we
also,
go by his counsels.
Article 50 talks about fair hearing, and also 47 fair administrative action. So in that case, until proven guilty, he has all the rights to seek refuge in courts.
And
I must say, in fairness, every lawyer will tell you that somewhere in his practice of law, if you litigate often, witnesses do fall ill quite often, sometimes. And sometimes it's not even just falling ill. We've had witnesses not appearing in court. We had one recently who I could not get a witness in court because of the strike by the airport staff.
Yes.
oh,
And you go and you explain,
It's
and the
beyond
court
them.
allows you, yes, that something has happened that is beyond them, not this, in spite of our best intention to be there and best efforts, something happened that intervened and made us unable to appear on that day. Illness certainly is a sure one.
it's considered to be beyond one.
It's not his intention,
Yes,
yes.
it's not an intentional thing.
let's wait and see what Senate comes up with.
Okay, I think it's what? It's now 16:59 hours. So we are meant to be, in the next minute, we are meant to be having the Deputy President tabling his evidence before the Senate. We will now have a split screen of outside Parliament and inside the Senate, and you can see some senators are just bantering, huddled up in small groups. Some are walking in at the moment. It's 5 p.m. and we are yet to see white smoke in regards to the Deputy President arriving to table his evidence in the matter of this trial of which is on the impeachment process against him. And excuse me, the Speaker is yet to get into the House. There was a shot there of his seat and it's still vacant, so he's in. Again, it comes to the concerns that have been raised here, and as well as on the phone call we had with the other lawyer, Manwa, in regards to
fair trial in terms of being heard on this whole matter. And I mean, I'm imagining if for some reason this is extended, just the atmosphere around the country, you know, people, there's some anxiety that would be there around the country, you know. So I don't know who could take this. Do you guys feel it would be important for the president to kind of make a statement? Because he's been very silent about this whole process. He's not, even when he has gone to events where, you know, as politicians, they would jump into a certain conversation. They'll be talking about the launch of ABCD, but somewhere there they'll mention something else that is of, you know, a topical matter. So do you feel it would be of value for the president to speak now?
For me, I don't understand politics.
Yeah.
Politically, probably somebody might tell him he may need to say something, but constitutionally and legally, I would tell him not, because this is a parliamentary process over which he has no direct control. At least we can say that constitutionally. So
yes.
This has nothing to do with him. So I would just let whatever's play out as it should. Okay? Maybe the speaker would be the person to maybe say something on behalf of Parliament, because that's the arm of government that is involved here, that we need to say something about it to the rest of the country. Yeah. That's what I would say. I would think.
And when you speak about the speaker, it's interesting that yesterday he was mentioned because of the whole thing of shareholding. And I think I see, is that the mess? I think the speaker has arrived. I'm not sure. Once we get the shot, he's not yet arrived. We are still monitoring the shots there. But I was saying the speaker was mentioned and came to the whole conversation around shares, because he is one of the people who got, he's a partner of PA. And he was part of the agreement by the administration. And yes, I can see he's working now. It would be interesting to have seen his reaction when the lawyers were speaking about it.
So let's just cross over fast to the Senate and hear what the Speaker has to say, as well as the rest of the people in the chambers.
Senior Counsel Muite is in the chambers.
Order, Honorable Senators. Senator Boni, please take your seat.
Now, Honorable Senators, I did suspend the sitting of this House to allow Senior Counsel Paul Muite for the Deputy President, one, to locate his client and report back at 5 so that we may proceed with these proceedings. Senior Counsel Paul Muite, you may now inform the House so that we proceed.
Mheshimiwa Speaker, through you, I would like to inform honorable senators that I've been able to contact the doctors at Karen Hospital. There are a number of doctors, a team of doctors, who are looking after the Deputy President. Because of his condition, I was not able to directly talk to him on the advice of his doctors. He said he must have complete rest for the time being. I was, however, informed by his doctors that he is currently suffering intense chest pains. I did not want to inquire beyond that, Mheshimiwa Speaker. But just in order to perhaps save the time of this Honorable House, let me, as I sit down, invite shall, after according the President an opportunity to be heard, vote on the impeachment charges. Mheshimiwa Speaker, we are aware that this Honorable Senate made a decision to hear the charges in plenary, so that what we are doing in these proceedings, I would suggest and submit we are proceeding under sabbatical 6B. And under sabbatical 6B, this House, by the Constitution, is obligated to accord the Deputy President an opportunity to be heard, which is why Rule 11 of the standing orders of this House specifically provides, Rule 11, where the National Assembly or the President chooses not to appear. And I would like to submit that the Deputy President has not chosen not to appear. The choice of the language chooses to appear in Standing Order number 11 is to be read with the Constitution Article 145, Sabbatical 6, which obligates this Honorable Senate to accord the Deputy President an opportunity to be heard. So I do leave the matter in your hands, Mr. Mheshimiwa Speaker and Honorable Senators. I would suggest Article 145, the sabbatical, I've read sabbatical 6B, doesn't have a time limit of 10 days. Give the Deputy President, in the interest of justice, given the weight of removing a Deputy President from office, give him a couple of days. I thank you.
So if I get you correctly, Senior Counsel Paul Mwite, it is your application to the Senate that your client be given a couple of days. Now, a couple of days doesn't mean much.
That is the application. What I had in mind, I would add the word humbly requests Mheshimiwa Speaker and this Honorable House, the Senate, a couple of days I had in mind up to Tuesday. We should be able to know when the Deputy President is able to come and defend himself. I thank you.
Counsel for the National Assembly.
Mr. Speaker, sir, Permit me to start by registering our greatest sympathies and empathies and from the team, the National Assembly. Of course, issues to do with health are issues that are beyond our control. Mr. Speaker, sir, that said, we also would want to be cognizant of the fact that we are dealing with a constitutional moment. We are dealing with an item whose timelines are prescribed within our Constitution. Mr. Speaker, sir, contrary to what learned senior counsel, Mr. Paul Mwite, would want to persuade this House to believe, the proceedings before this House have not been the subject or have not been transacted pursuant to Article 145(6). Mr. Speaker, sir, on the 9th of October this year, this House did sit, did pass a resolution pursuant to the provisions of Article 145(3). Mr. Speaker, sir, pursuant to that resolution, there was a Gazette notice which very clearly indicates that this House was not going to determine that the matter at hand from a committee perspective, but that the whole House would then be determining the matter.
It then follows, Mr. Speaker, sir, that the provisions of Article 145(6) would not be applicable. Mr. Speaker, sir, in the same Gazette notice, you did gazette the 16th and 17th of October to be the days assigned for the hearing and determination of the motion that is before you. That said, Mr. Speaker, sir, we appreciate the place of fair hearing and an opportunity to be accorded the chance and the facilities to be able to defend one's self in a motion such as this. Mr. Speaker, I would want to add that the opportunity to be heard in the proceedings, both before the National Assembly, where they filed a very, very detailed replying affidavit and a response. Mr. Speaker, sir, to be represented, they could elect to come in person, they could file documents. Mr. Speaker, sir, His Excellency, the Deputy President, has participated the 8th of October 2024. When the proceedings before this House began, His Excellency, the President, the Deputy President, again filed a very robust response dated the 12th of October 2024.
Mr. Speaker, sir, up to this point in time, His Excellency, the Deputy President, together with his team, have had a beautiful opportunity to present their case. They have had an opportunity to cross-examine.
A very robust response dated the 12th of October 2024. Mr. Speaker, sir, up to this point, if any prejudice were to be occasioned in the course of this, hearing this matter, that prejudice would be on us because our opportunity to present their case. They have had an opportunity and avail an opportunity for the National Assembly to all the witnesses that we presented before this House. The circumstances that we find ourselves in. Having also very keenly heard learned senior counsel speak, matters would be on us because our expectation would be that His Excellency, the President, would be able to attend and avail an opportunity for the National Assembly to cross-examine him. Mr. Speaker, sir, taking into account the circumstances that we find ourselves, there is clarity and certainty that we'll be able to proceed on that assigned day. Matters held are not matters to be taken lightly. On the same tone, Mr. Speaker, that as accorded to other similar organs created by the Constitution, cannot be certainty that if an adjournment were to be given even for 1 week, then there is clarity and certainty that will be able to proceed on that assigned day to fair hearing, and that fair hearing does not necessarily. We would urge that we borrow practice that has accorded to other similar organs created by the Constitution. I have the courts of law in mind. Mr. Speaker, sir, because I earlier on submitted that Article 50 provides for an election that we have had parties file submissions and their documents, and that does not necessarily have to be oral, for the courts to highlight those documents. Some of the most important decisions of our lifetimes, including decisions arising from presidential elections, have, in all the elections that we have had parties file submissions and their documents, and that their advocates have had an opportunity to appear before the courts to highlight those documents and pleadings that have been filed. In this occasion, because His Excellency the Deputy President has had an opportunity to present all the material that he ought to or he wanted to present, and also had the opportunity to cross-examine all the witnesses that he wanted to cross-examine, all that is left on their side is highlighting. On our part, Mr. Speaker, sir, the part of the National Assembly, so that then we are able to give progress to this matter, we are willing to take the painful decision to forgo the cross-examination of His Excellency the Deputy President and only proceed with highlighting submissions in relation to the documents that we have filed before this House. It is our humble view that no prejudice would have been occasioned to His Excellency the Deputy President. Mr. Speaker, sir, we urge that if I had my learned senior colleague, Mr. Paul Mwite, Senior Counsel, well, he seemed to have been imploring this House to consider adjourning. Mr. Speaker, sir, let me end by drawing the attention of this court to Rule 12 of the proceedings, the rules governing the proceedings currently underway. Mr. Speaker, sir, Rule 12 being an organ of a constitution that is that once the hearing has commenced, it shall proceed up to the end. It does not provide for an option for the House to adjourn. If that is the dictate, Mr. Speaker, sir, of the rules governing the proceedings before this House, we urge that being a country, being an organ of a constitution that is that is controlled by the rule of law and the Constitution, you direct that we proceed with the hearing as had been planned. I am most obliged. Mr. Speaker, sir, just before I leave the ground, maybe I would want to invite my leader, Mr. Honorable James Orengo, Senior Counsel, to also just add one word before you give your directions.
Mr. Speaker, just briefly, in these proceedings, we are governed by the time bound. There is a very unique provision in Article 145 that you don't find in legislations. That article is there to deal with a situation like we find ourselves in, because the makers of this constitution knew that when processes are time-bound, they must be a safety valve. Article 145, sub-article 5, which applies mutatis mutandis in relation to the removal from office by way of impeachment of the Deputy President, states as follows: the President, and for that matter, it should be read, the Deputy President, shall they have the right to appear and be represented before the special committee by his advocate or by him appearing in person or having both the deputy. In a lot of legislation, you find the right to be represented highlighted. Now, I want to put the Deputy President can elect to be represented either if, in accordance with the election law, you are required to both the Deputy President and his advocate to appear. Now, I want to put before the Senate, you're told that you must present your nomination papers on a certain day, as it is there in the law, to subscribe your nomination papers on a certain day, and you fail it. You're running for president or deputy president, and you're told that not give you any accommodation. You'll be out, and there are a lot of decisions on this matter. I want to talk to this. Would you feign sickness and fail to represent your nomination papers on that particular day? And I can tell you, if you fail to do so, the law will not give you any evidence, credible evidence before the House that has been admitted. Even that evidence that has been admitted to a medical institution, we don't have it. We will rely on the evidence from my senior counsel, Paul Mwite. That is evidence. But in practice, I can say without a fear of contradiction, there are many times where people are represented even in medical documents and later on. And if I can give evidence from the bar, he went to his office, and again, there's no evidence that he was evacuated in an ambulance. He went to Karen Hospital in himself to check at the hospital. So I think our constitutional duty is to live by what the Constitution requires of us. The greatest prejudice, for me, I was looking forward to cross-examine the Deputy President. But unfortunately, the story that has been told does not include cross-examination of the evidence of the Deputy President, which is on record. But because we are time-bound, and as my London friend Eric Gumba said, we are prepared to go by the evidence in record. The prejudice is to us. The sickness of the Deputy President is affecting us more because we would want to cross-examine him. But he has evidence in record which we cannot test by the way of cross-examination. And there's no assurance that on Tuesday, the Deputy President would be here. Finally, we can also say from here that there are many cases that have been filed all over, including in Malindi today, that has to do with the proceedings that are going on here. So I am in a position to say that this health condition in which the Deputy President is, and I sympathize, may be opportunistic in the absence of medical evidence from a doctor. It may be opportunistic. And I saw him when he came in. I'm not a doctor, but there was nothing to suggest that he was in the condition that Honorable Counsel has been talking about. So do the senators now turn into a jury to make a decision on the basis of evidence presented from the bar by senior counsel without what ailments is suffering for? I think the more important duty for this Senate is to what ailments is suffering for. I think to comply with the Constitution and proceed with the hearing of this impeachment proceedings. Thank you.
Senior Counsel Paul Mwite.
Of this impeachment proceedings. Thank you.
Senior Counsel Paul Mwite.
Mheshimiwa Speaker, Honorable Mheshimiwa Speaker, Honorable Senators, we all live in these gadgets we have here capture every word uttered accurately, so that if I was found tomorrow to have lied to these senators, sanctions can be brought on me. And I would have thought that that fear of telling a lie to this honorable Senate, to me, is more powerful than even bringing a medical report. We've had many medical reports generated outside hospitals. We see them in courts almost on a daily basis. Mheshimiwa Speaker, you will remember the rush that was there when I was asking to be given up to 5 p.m. And it was a rush. Was I to fail to come back to this honorable house at 5 p.m., waiting for a medical report when the doctors there are busy attending to their patient, the Deputy President? Medical reports I can bring. If I've told lies, that is something that can be established. And my learned friend, Mheshimiwa Honorable Orengo, talks about giving evidence from the bar. When I was learning, they are seated down when he's giving evidence from the bar about some cases filed in Malindi that I'm not aware of. Perhaps he should have given us a copy of that. Perhaps he should have given us 145 Sabbatical 6 is clear, and I do not want to take time of this august House, Senate. Going back to it, it applies, and I would plead with you and with honorable senators to give us until Tuesday to see whether the Deputy President will be well enough. No one decides when to get sick and when not to get sick. I am sure many honorable senators here will have a story to get sick. I am sure because of having spent an evening with somebody, then the following day they hear that the person is gone. Yet that person was looking good and healthy. Let's be humane. Let's be compassionate. Tuwe na utu kidogo. Tuesday, the heavens are not falling down to join with the earth. I thank you, Mheshimiwa Speaker.
Senior Counsel, Paul Mwite. There is a hypothetical question that was raised by Senior Counsel, and just an assumption. Assuming the Senate is inclined to grant your client up to Tuesday, and by Tuesday, your client is unable to attend Senate, what then will be the way forward?
Mheshimiwa Speaker, I would submit the best thing is for this honorable House, honorable Senate, to make a decision on facts rather than assuming what may or may not happen. Point number one. Point number two, Mheshimiwa Speaker, is the importance of honorable senators seeing with their own eyes how a witness withstands cross-examination. There are many times when different impressions you'll be given by a written document. And yet, when cross-examination takes place, individuals change their minds. One can only make a decision on whether this witness is believable or not believable when they see his demeanor in person. So there's nothing to replace orality through cross-examination. There are many witnesses whose statements will be impressive, and yet when they begin to give evidence orally, that impression changes completely on the mind of the jury. The Deputy President wishes to subject himself to cross-examination, wishes under oath to deal with the evidence given adverse to him by witnesses here, so that honorable senators can have an opportunity of making a decision. Is it the Deputy President we shall believe, or is it those other witnesses? That opportunity can only come through orality and through cross-examination. So what this House elects to do, that decision, this House, Mheshimiwa Speaker, they will make on Tuesday. I am always an optimist. So I am living in the belief that the doctors may be able to put whatever is wrong with the Deputy President back in place so that he can be here on Tuesday, Mr. Speaker. If he's not here, let that decision of what this Honorable Senate will then do be made on Tuesday. That is a humane way of going about a matter about no one had control of. I thank you.
Now, honorable senators, having listened to the counsel for the Deputy President, as well as the counsel for the National Assembly, I need to consider those arguments and give my considered ruling in this matter. I will therefore suspend for 5 minutes. 5 minutes. 5 minutes, and I'll be back. Arise.
There you have it, another 5 minutes for us to wait that we can know what the verdict is in regards to the matter that is before the Senate in regards to the Deputy President being unable to attend and table his evidence in this case of his removal from office by way of impeachment. And on your screens you could see we are also live at Karen Hospital, where Paul Mwite has said the Deputy President is admitted. Our team is already there trying to see whether we can get any information, any kind of communication and pictures regarding the same. So we are on location. Where the story goes, we follow. And so we shall be giving you updates on any developments from that end. And excuse me, we've seen a couple of interesting submissions there which are pro and against what, for instance, Seku and Roslyn, we've seen that Mwite wants to be given what initially called a couple of days, but now he was pushed to give a specific timeline, and he said Tuesday. But the other side were arguing that we have no guarantee that by Tuesday the Deputy President will be able to come and do what he's expected to do. Then what? But Mwite has insisted that he would rather deal with fact than presumptions. Seku, what was your feeling after listening to the submissions right there?
Okay, what I get is that the parties are at different odds. Senior Counsel Mwite would like an adjournment, technically speaking. The National Assembly's advocates, Senior Counsel Orengo and my colleague Eric Gumbo, would like this to proceed. They are basically making a concession, saying, look, go ahead, let's take the Deputy President's witness statement for what it's worth and conclude. I think they are keen to conclude it today. So that's what I think the Speaker has to think about and mediate. I don't know what he will decide. They seem to be torn because there's an issue here. There's a humanitarian issue here.
Yes.
The Deputy President is unwell. He has rights which need to be preserved. He would have wanted to be heard. The other side and the National Assembly on the other side is concerned about the time limits in their reading of the Constitution, which says a decision must be made by the end of the day today. They seem to be suggesting, and I think that there's a point there, that even the adjournment that is sought, can the Senate make that adjournment? That too is a question that can be challenged in court when we go that. Can you adjourn and extend time by yourselves for something for which the Constitution, for a process for which the Constitution has set limits? So that I think it's what is playing in the minds of everybody else and saying, whatever decision we make here, it probably will end up in court. On which side of it will I end up when the court makes a decision? So everybody needs to be, they're actually walking on very thin ice.
I know.
In this particular case.
Rosalind?
On both sides.
Yes.
Dan, we are in a very unprecedented times. And I think when we started, we talked about it, that this is indeed a constitutional moment. This is something that we didn't anticipate, and I don't even think the senators expected that things will turn out to be what it is. We've seen the Speaker retreat to consult and give a reasoned judgment. I know he will consult the legal team from Parliament to also get to see which is the way forward to wiggle that will also not land Parliament in court, that can give room for the defense, the Deputy President's defense, to actually challenge the impeachment process. But if you had Senior Counsel Paul Mwite, when he was submitting and humbly requesting the Senate to extend time and allow the Deputy President to recover before he can actually come and take the witness stand, he was making reference to Article 155(6)(b), which actually makes reference to a select committee, whereby the accused actually comes before the 11-member select committee and put their defense. But you saw the National Assembly defense team led by Eric Gumbo making reference to the resolutions of the House that made reference to a plenary session and not a select committee.
Allow me to just interrupt you briefly there. Before because I know the Speaker ideally by his timeline is going to be back. I want us to cross over to Karen Hospital, where Brian Moshiri is on location, to just give us a sense of what's happening there. Brian, good evening. This is a pretty high-level personality who has, according to his lawyers, been admitted at the Karen Hospital. Have you seen any kind of activity there to indicate as such, and have you gotten any kind of information regarding the same, confirming that the DP is there?
Well, thank you very much, Dan. Like you've so rightly put it, we have been following for the past 2 days that the impeachment motion on Deputy President Rigathi Gachagua. Indeed, earlier on in the afternoon, his lawyers, led by Senior Counsel Paul Mwite, did engage the Senate and just indicate to them that he had been brought here. Dan, the activity is minimal. However, just perusing around, and individuals within this particular hospital that I have spoken to in person, that I can confirm, have indicated that indeed Deputy President Rigathi Gachagua was brought here. However, they are not willing to give any further information. Again, we have not seen any form of motorcade that you would expect or accord this high-level profile. we just have seen the hospital continues to engage like you expect. Individuals coming in to see those who are sickly, coming in to visit those who are sickly. Individuals also walking in and driving in just to engage with this particular hospital and this particular apparatus that is the Karen Hospital, that has been pretty monumental when it comes to matters health, as far as politicians and political individuals and high-ranking members of the Kenyan society are involved. However, Dan, the Currency Road Hospital, or the Karen Road leading to this particular road, is still moving as you would expect. No out of the blues or no random motorcades or any form of movement like you'd expect from police officers or from any entourages that you'd expect or you would accord the Deputy President to have, should he be this, or rather as it has been put that he is in here. Though, Dan, we have seen and we have engaged with a few individuals from the security space within this particular area. Earlier on, we had been shoved aside from this particular area. One of the security, who I presume is the lead security individual within this facility, that's the Karen Hospital, did shove us out of this place, or at least from this facility, for a few minutes before we could explain ourselves. He says that the family of Deputy President Rigathi Gachagua at that time had an issue with their own form of privacy with regards to the man that is Deputy President Rigathi Gachagua. However, our engagements have also been alive to the fact that this is a man who is a public officer. This is a man who is the Deputy President of the Republic. Therefore, matters to do with stuff like his health or where he goes at times is actually eligible to public scrutiny, like you would see right now, Dan.
Much, Brian, and we shall be linking up with you later on, because now that Paul Mwite has made it public where the Deputy President, according to his statement, is admitted, we'll wait to see whether there'll be other leaders who will be going there to visit him, and Brian Moshiri will still be there for us to just give us updates live on location, even as he takes the necessary precautions in light of, as he has said, the security concerns, in terms of the security team's concerns, which he says are concerns from the family. And so just a quick recap is that according to Paul Mwite, the Deputy President, that is Rigathi Gachagua, has been admitted at the Karen Hospital, which is in Karen area, which is in Nairobi County. Mwite says he did not speak to Gachagua himself. He spoke to the doctors there. And he says that there's a whole team of doctors that is looking after the Deputy President. He was not able to directly speak to him. He says that the doctor he spoke to said that Rigathi Gachagua must have complete rest for the time being. And he said that he is suffering intense chest pains, but he said he was not going to probe further on what the dynamics of that are. And so this was what informed his request to have an adjournment until Tuesday, after which then he says that we will see if the Deputy President would be able to make it to the Senate to continue. And so after that back and forth, then the Speaker of the Senate has retreated to go and, in his words, consult. Then he can come in and make his ruling, his considered view after his view after he has consulted. Roslyn, you're in the middle of saying something.
Yeah, I was saying that the legal counsel for the National Assembly, Eric Gumba, and I think also senior counsel James Orengo alluded to it, and they were objecting to the proceedings being suspended and making reference to the Constitution that indeed the presentation that had been done by his legal team and his own statement can actually be used to allow the Senate to proceed and take a vote. But you've seen Mwite insisting that indeed he needs to be accorded an opportunity to actually also present his case and also be cross-examined. Where that leaves us is a very dicey position, because again, when it comes to sickness, and even the legal team of the National Assembly empathized with the Deputy President and said you cannot determine when somebody will recover or not recover, because as we see it again, in terms of privacy, you cannot actually also go delve into the details of somebody's sickness. So as a country, we find ourselves in a very difficult spot, because there are those people who are very anxious to see this process end. Other Kenyans will also just want the Deputy President to have his time and recover fast before he can actually go through the trial process. There's also the constitutional timelines that again restrict the Senate to actually be dispensed with this matter as per the Constitution. And that is why you see, even for the Speaker, he has said, let him retreat, consult, and then come and guide the House on the way forward, which I know, despite whatever decision the Speaker will take, he will also open it to the members to also voice their concerns and debate, and maybe take a sound position or even take a vote on it. So I think maybe those are some of the issues that we will see pan out in the Senate as the Speaker comes back.
Okay. Seku, for the benefit of those who may not really understand the workings of around the Senate and the Speaker's office, what kind of a team, if you would know, does he have in terms of the legal team?
Serious.
I know I know Parliament. That would be both National Assembly and Senate have legal departments, which has lawyers from draftsmen to in-house counsel to people, advisory people who advise members of Parliament, assist in drafting and drawing up legislation, bills, and things of that kind. So he has a legal team, in my view, are fairly experienced and would be able to assist him, bounce off his ideas, help him in his research, in generating the decision he has to make.
And he himself is a lawyer.
Yeah, he himself is a lawyer, yes.
You could imagine, I mean, you could just only imagine the caliber of lawyers needed for such an office, because when you're making some key decisions, some very, very crucial decisions, you'd need a very solid team. And I'm curious whether, he would have also invited other senators, be it the leaders of the majority and minority, to join in those consultations, or whether that now sits entirely with the Speaker's office. It would be good to know whether he has done that, even as he comes forward to make this announcement. So far, it's definitely past the 5 minutes he had asked for.
Maybe you will have also included the House Business Committee members, just to be able to agree, because whichever direction they make, if they have decided to proceed or to suspend, it should be a wholesome decision that they have taken. And that's why I think, even as he had said 5 minutes, it will be more than 5 minutes to be able to also consider the reasoning of both parties. Do we ignore what the Deputy President's legal team wants and proceed, or do we take into consideration that? And that takes us back to the ruling by the Supreme Court. One of the undertakings that they made is that whenever there is an issue of an impeachment, then the courts must also review that. And I think that is where the Senate also finds itself on, because at the end of the day, whichever decision the House takes, it must be subjected to a review by the judiciary.
Okay. I think the country is, today there's a huge expectation around what will happen after this, how there'll be a vote. There was the whole banter around Rigathi might be
the final straw.
Yeah, I know those banter around Mashujade, he might be Raya, etc. So this does not look like it might be the case. Nonetheless, it has also, there have been conversations around, is this an orchestrated plan altogether? So Parliament, both houses have been accused of being rubber stamps, say, of the executive, especially the president. But there still is the value in the process. So maybe Seku, just think about the process. the value that we get from having a process, because we are seeing new things coming up. And I guess even processes that don't even allow for jurisprudence, etc. Maybe you could just speak to the value of having such a process happen altogether.
Yeah, as I said, they actually test, these processes are important because we have a constitution that we can say is fairly young, less than a decade and a half old, but it's already being tested to its limits and its seams. And it just tells us whether we have, from the experiences and whatever happens, the occurrences that happen both in politics and in everything else, governance generally, we then get to understand what really does it mean to have the kind of constitution we have, and are we really up to it in terms of what it requires of citizens. There's been citizen public participation, what it requires of legislators. They've been considering this, what it means for our Bill of Rights, because we have here a deputy president who has rights which are at stake in this. So it's all just the whole array of the constitution, how it interplays and what it means for the citizen. So these processes help us understand that, okay, this is how things are supposed to be done. These are the opportunities available for everybody. You get to understand everybody's rights. We get to understand everybody's obligations. And we get to understand why the whole architecture of a republic as Kenya is stated the way it is.
Okay, and I mean it does set precedents, but some that has also been a point of discussion, because I'm hoping we can demystify as much as possible. I know has been about the threshold of evidence that can be admitted into a case. When you compare what is being brought to the Senate vis-a-vis what would be expected in a court, for instance, all the videos that were being played, would they be admissible in court, for instance, or would there be a more rigorous process so that you can say this one has actually been verified to be, it is true?
That's a good point. And that's why we need to understand the distinction between how Parliament operates vis-a-vis how this operates. And when we say this is a quasi-judicial process, which is inquisitorial, that is precisely what we mean, that there are semblances of how a judicial trial would take place, but it is not entirely the full hog. So that if, for instance, the manner in which documents and evidence is presented in Parliament for purposes of impeachment would differ quite significantly from the way the courts are, because the courts have rules of trial, have also rules of evidence and admissibility, that in order for a video to be admissible, there's a way in which it must be presented. There's an authentication that has to be done. It must be accompanied by a certificate. For instance, if it's something downloaded off a particular gadget, there's a certificate. So all of that basis must be laid before it is done. So naturally, if this had been a trial in court, then the threshold is higher, because here they don't even talk about a burden of proof. They're just talking about the probability of something happening. Okay, so they're saying if it seems that this and this has been happened. If you were to go to courts, then now you must prove that something really did happen. If it's a crime, beyond reasonable doubt. If it's a civil wrong, or balance of probabilities. So there are specific now standards that must be met in order for a court to satisfy itself that something has been proved. So they'll be different.
So you're saying, for example, if there was the, like the videos, for instance, maybe just for clarity, if these videos were doing this was being prosecuted in court, what would need to be done so that these videos can actually be taken to be evidence?
They would not be submitted in the same way they were submitted. So for instance, if it's a video of a news broadcast, you've seen news broadcast from television, then you need to get a certificate from somebody within that broadcast station, for example, to say, look, this was our broadcast of this particular day, it has not been interfered with. This is really the broadcast of this particular day. So either somebody from the archives or from the library or an editor or even the newscaster or the anchor who was there that day says, yes, on 17th of October or 18th of October, I did this and that and that. I was the anchor at 9 o'clock, we broadcast this news and this was our reporter. Okay? As a way of authenticating it and say, this is the actual clip, and they'll probably take it from the beginning to the end. So they would not permit cuts of it. So as to assure people that nothing has been edited and that it has not been interfered with.
So what happens if you see nowadays the politicians usually have their own live streams. For instance, even right now as we speak, the deputy president's page, like Facebook page, for instance, is live with these proceedings, etc. And it was something that was picked off the live stream that he had, because he's maybe the only one who had access to that footage, right? So if such footage was to be, they've used a soundbite of his off that channel, who,
because then the court will then ask me, please bring that gadget if there was a challenge, and go behind it to find out if that gadget really was the exact clip that I downloaded. Yes.
So here, because here we are seeing them playing videos, some are refusing to play. I downloaded it because I saw like Mwingi Mutuse was saying that he downloaded it in his
HP.
Yeah, he given the details of his machine.
Yes. But you see, the argument here is this is a political process. So the burden of proof, and that's why as a mover, Mheshimiwa Mutuse was talking about political hygiene. So it's not a matter of proof beyond reasonable doubts. Is to bring to the attention of the House that either this has happened or this is going to happen. And they still go back to the issue of the Constitution Article 78 on the conduct of state officers. To what extent are you supposed to present yourself as a state officer in terms of the Leadership and the Integrity Act? So that is what he's banking on to convince the members that indeed the character of the deputy president does not befit the man who holds that office, and calls the senators to vote to that particular position that indeed he has not carried himself to fit the dignity of the office that he took out of office to uphold.
All right, and just to keep you updated, we're still monitoring to see when the Speaker of the Senate is back to give his the way forward in regards to this matter, as well as to see whether we'll get any further information at the current hospital where Paul Mwite, who is representing the Deputy President Rigathi Gachagua, has said the DP has been admitted and is, in the words of the senior counsel, experiencing severe chest pains and needs to have a lot of rest. And so we are waiting to see any developments on that end. So we are monitoring both Karen as well as the Senate as we continue to have our engagements, just to give further context into all of this. Now, Seku, there was a point of departure between what the counsel for the Deputy President was arguing vis-a-vis the counsel for the National Assembly. So Mwite was saying that we go by Article 145, sub-Article 6, which talks about if a special committee reports that the particulars of any allegation against the President have been substantiated, the Senate shall, after according the President, or in this case the Deputy President, opportunity to be heard, shall vote on the impeachment charges. But even when we are listening, Seku, you are not seeming to be in agreement with that.